each one of you. On behalf of Bangalore Chamber of Industry and Commerce, we welcome you all for this exclusive session on services of information utility benefits to operational creditors. The session is jointly organized with National E-Governance Services Limited under the aegis of Banking, Finance and Corporate Affairs Expert Committee. The Chamber acknowledges the support of NeSL by way of Mr. Devajyoti Rai Chowdhury, who is the MD and CEO. Hearty welcome to you, sir. Thanks for your support. We also welcome Mr. UV Rao, who is the Head Operations of NeSL, and Mr. HB Vaidya, Executive Relationships of NeSL. Thank you very much, sir, and welcome to BCIC. The Banking, Finance and Corporate Affairs Expert Committee is chaired by Dr. K.V. Prakash, who is also the Associate Advocate and Founder Director of Consentia Consultancy, co-chaired by Mr. Joydeep Nag, who is the Head Technology of Amrita Vishwa Vidyapeetham, and Mr. N. Venkat Krishnan, who mentors the committee, and he is the advisor of Tata Hitachi Construction Machinery Company. Welcome to all of you once again. The Chamber acknowledges the support of our members by way of annual sponsorship. They are Bueller, Futtermans, Wipro, MTR, and Sona Group of Companies. Thank you once again, all of you, for joining this session. I now hand over the platform to the chair, Dr. K.V. Over to you, sir.
Good evening, everybody. Are you able to hear? Hello?
Yes, sir.
Yeah, we
We
can.
are able to hear you, but not able to see you. Your video is off.
Okay, no problem. Um, Good evening, everybody, and welcome to this yet another webinar series from the BCIC. This is in association with the NeSL, who are the only information utilities formed under the IBC, and we have our speaker and chief guest, Shri Devajyoti Rai Chowdhury, and Team NeSL to interact and discuss about their various services to the corporates and also the borrowers and lenders. So this is the topic today we are going to deal with, and I will be moderating this session in a manner so that everybody benefits. And before going into the subject, I would introduce Shri Chowdhury, who is an MBA from the Faculty of Management Studies, Delhi, and certified associate of IBB, that is the Institute of Bankers. He is a passionate leader with a long track record of successfully managing assignments of a diverse nature. Immediately prior to joining NeSL, he was Chief General Manager in the Insolvency Bankruptcy Board of India, that is IBBI, where he took some path-breaking initiatives like the implementation of companies' registered valuation and valuation rules 2017. His articles on issues relating to insolvency have been published in reputed publications, national newspapers, and he has been a speaker in numerous webinars, seminars, workshops related to corporate insolvency, and also in prior to joining IBBI, he was at the corporate office of India's largest bank, SBI, where he was responsible for compliance and risk and implementation of insolvency and bankruptcy code at the largest business vertical. Among his other assignments in SBI, he was in charge of setting up SBI's Dubai's operation as a highly profitable unit within a short span of time. As the CEO of SBI, he was much sought after by the Indian banks and also the Indian community for his views on issues like Indian economy, personal investment, trade flows, and exchange rates. He was also conferred the Business Excellence Innovative Best Practices Academia Awards 2020 by the New Delhi Institute of Management. I hereby welcome Mr. Chaudhary to give a note and give the keynote address. Welcome, sir.
Yeah, thank you, Dr. Prakash. Uh, Good evening, everyone. And I'm most grateful to the Bangalore Chamber of Industry and Commerce, and of course, Dr. Prakash himself for taking so much pains in having organized this webinar. And of course, I'm also very grateful to all of you who have logged in to hear Team NeSL at this webinar. Now, a detailed presentation will, of course, be done by my team. But I will try to explain the importance of the information utility, that is NeSL, by narrating two small stories. A few days back, one of our marketing persons, of course, he had just recently joined a company. He came back from a marketing call from an industry association. He had a very sad look on his face. Sir, they said, why should I submit information to the information utility? In any case, in the corporate insolvency resolution process, operation creditors do not get anything. So I said, son, that is the point. By submitting information to the IU, you can avoid going the insolvency resolution process. Let me tell you how. By submitting information to the information utility, you get access to the credit history of the debtor. Now tell me, as a supplier, would you ever come to know if the checks issued by a customer has bounced? No, you will not. But if you are registered with the information utility, you will come to know whether your customer has defaulted to some customer or a debtor goes through stress. He defaults not to banks, because otherwise banks will take stringent action. He will default to small suppliers. And sometimes you will not even come to know. But if you register with the information utility, you will come to know. And that my colleagues will tell you how. You can immediately take steps to protect your interest. You ask, in fact, you can ask for a letter of credit or advance payment, or even say that this is my credit, I cannot go beyond this. Also, through the information utility, you can come to know about the lending patterns of banks. You know, some banks are very smart. They come to know that some borrowers are going through stress. They come to know much in advance, and they start reducing the exposure. So when you become a user to the IU, you have access to all this information. Now the second story. This was a large operational creditor, large company, large corporate, and he was aware of the IBC, also about the information utility. I was very happy to know that. But then he says, sir, I want to use IU, but I want to know only when the public announcement for insolvency happens so that I can submit my claims on time. I said, sir, it is too late. That is too late. There is a saying in English, it is no use locking the stable when the horse has bolted. By the time the corporate insolvency starts, the corporate debtor has lost all its value. So you have to start submitting information earlier. When you do that to the IU, when the going is good, you come to know when the debtor is going through some stress. and is about to default to its creditors, then you can take preemptive action and avoid any loss. As Dr. Om Prakash stated in his opening remarks, I was CEO of SBI's Dubai operations for almost half a decade. Now, in the initial part, I also set up SBI's operations in Dubai. Initial part, we were desperate for business. We started with a zero balance sheet. So we are desperate for business. Now, I came to know a subsidiary of a large Indian company. If I tell you the name of the company, you will all know, but I don't want to take any names here. Subsidiary of a large Indian company, private limited company, of course, it had its factory in Dubai. Now, we were desperate to get some business, to grow a balance sheet, and we wanted to get some business from this company, some part of the credit business of the company. So I called up my India office and requested them, sir, please put in a word so I can get some of this lending business. But I was shocked to learn from my India office that the company was in deep trouble and was in fact defaulting on its suppliers. The only point I'm trying to make here is that in the normal course, suppliers do not come to know about the financial condition of the customers till it is too late. But by submitting information to the IU at a very nominal cost, suppliers can get access to crucial information that can prevent any loss on account of default by their customers. Now, in my discussion with operational creditors at various fora, one reason given by OCs for not submitting information to the IU is that their customers might get offended. My response is that if more and more OCs start submitting this information, this will be seen as usual and this will be accepted in due course by the customers. When there's delay in payment of an invoice, often suppliers are hesitant to report to the IU because they fear it will lead to dry up of further orders from the customer. But I am saying, please submit non-default information where the customer is not defaulted. So there I think customers should not object. By submitting non-default information, they will get information about default or stress in the debtor from the CFR and other reports of the IU. They can even prevent a situation of default, which can happen anytime later. Another aspect is that delay in payment often happens from solvent customers. They can pay, but they will not pay. Now, you can of course keep on waiting for your payments patiently. But please be aware that IBC recognizes payment of even by one single day. Even payment by single day is recognized as default. So if you want your payment, report it to the IU. You just see customer would promptly make payment to you as he would not want his reputation to be tarnished. There is a risk of not getting orders from the customer. But sometimes the situation has to change. How long will you keep on waiting? Waiting. A movement has to happen. If a customer has promised to pay by the 90th day, he should pay by that date. If reporting of delayed payment becomes common, now customers will also accept it. They will either pay on 90th day or say, give me higher credit period, which is good, as this brings about certainty in payment. Moreover, you may keep on waiting. Someday payment will happen, but that day may not ever happen, because in the meantime, if corporate insolvency resolution process happens, you see the experience of operational creditors. What they get from a corporate insolvency resolution process is negligible. But submitting information to the initiating of corporate insolvency resolution is also an option. You can initiate based on the record of default issued by the IU. If you use a record of default, there is a good chance that your application will get admitted very fast. And even if after it gets admitted fast, he might make a full settlement. He might even make payment of all your legal charges. That has been an experience so far. So there are a lot of benefits to submitting information to the IU, and my colleagues will go through all the details, and I'm also there. If you have any questions, I'll be very happy to address them. So I'll stop here now, and I'll request Dr. Prakash to carry forward the proceedings.
Thank you, Chaudhary ji. It was a good insight, and the importance of payment is very important in a transaction. If a guy fails to pay, there are trumpets blown across, and one of the trumpet is your insolvency procedure. So now I call upon Mr. Venkat Rao for the detailed presentation. Rao, you are there?
Yeah, I'm here. I'm going to share my screen.
Participants can shoot their queries in the chat box so that I can pick it up and shoot it across.
So thank you, Om Prakashi. So good afternoon to the officials of BCIC and all the participants. I'm Venkat from NeSL Bangalore. The present presentation covers about 20 to 23 material slides and likely to take about 35 minutes. To start with, we shall briefly discuss the relevance of IBC to operational creditors. IBC, first sentence is IBC protects the interests of the operational creditors also. In a trade credit, both creditor and debtor work with mutual trust. They would be honoring the commitments as per the trade practice and arrangement between them. But in certain cases, for a variety of reasons, the debtor may not be promptly honoring the commitments. If the creditor is having the necessary financial strengths to withstand, he may wait. But all the creditors may not have the necessary financial muscle to wait for longer periods. In such events, creditor explores various options for building pressure on the debtor for recovery, especially when the efforts of persuasion for payment fail. These steps like addressing reissued post notices, sending legal notices, filing money recovery suits, etc. Even such processes are long drawn, and they too may not result in instant recovery to the creditor, because the debtor can also protract the litigation to gain time. Beyond this, it may strain the relationship also. In such cases, the insolvency code, with the insolvency and bankruptcy code, the trade creditors have got yet another option of actions under IBC for building pressure on debtors for recovery of the stuck up trade credit, payment for trade credit. When there is a default by an operational creditor, the operational creditor can initiate corporate insolvency against the operational debtor subject to certain conditions. As per the experience in NeSL, in many cases, immediately on receiving the authentication invitation email from NeSL, debts were settled by the trade debtors. There are many success stories where operational creditors have filed data and default into NeSLIU, and NeSL on NeSLIU triggering the authentication invitation emails, with the fear of their being dragged to the corporate into insolvency process under IBC. In many cases, creditors call the debtors and settle the matters. In some cases, recoveries are received by operational creditors when they have obtained record of default from us and threatened them on the actions under IBC. Virtually, it is something like playing with the psyche of the creditors because there is a threat of losing control of the management of the company if insolvency resolution process is commenced against the corporate. When the operational creditor values the image and reputation in the market, he will not allow the operational creditor to drag him to NCLT with actions of insolvency. We are going to discuss what are these conditions in the forthcoming slides. In cases where CARP against a debtor is initiated by another creditor, operational creditor can file their claim for settlement on the strength of the data filed into IU. Further, primarily, financial creditors are the members of the committee of creditors in the insolvency resolution process enjoying voting rights. But in cases where debt of operational creditor amounts to a minimum of 10% of the total debt, such operational creditors are also granted right to attend the COC meetings, but of course without voting rights. Section 39(2) of IBC points that payment to operational creditors would be more than the liquidation value of the debt. In effect, the minimum payment of operational creditors under a resolution plan could not be less than the liquidation value of such an operational debt. These are the provisions of IBC. Then we in NeSL would be receiving many phone calls inquiring whether IBC is useful to the operational creditors also. Many are under the impression that it is useful mainly for banks and financial institutions only. This is not so. This slide indicates that right from the year 2016 when IBC is implemented till 31st March 2022, cumulatively a total number of 5,254 CR applications filed by creditors are admitted by the adjudicating authorities. Out of these 5,254, 2,699 applications are filed by operational creditors only. That is to say, a major chunk of about 52% are filed by operational creditors. Financial creditors filed only 42%. All these operational creditors found the IBC initiative to be useful to them in meeting their recovery needs. Next, when we see the current status of resolution of CIRPs, this slide shows that the statistics about the current status of resolution of those 2,699 applications filed by operational creditors only as at 31st March 2022. Out of 2,699 cases filed, about 530 cases are closed by appeal or review or settlement. 416 cases are closed by withdrawal. 163 are closed by approval of resolution plan. 718 cases are closed by commencement of liquidation. In respect of 872 cases, CRPs are going on. That is to say, ongoing CRPs constitute about 32%. This goes to show that about 68% of the cases filed by operational creditors are closed, and this is a fair percentage of success. Therefore, the figures given in this slide, which are based on the quarterly newsletter published by IBBA for the quarter ended March 2022, tell the tale on the utility of IBC to operational creditors. We are not going to going deep into the details of the definitions of operational debt and operational debtors. All the participants are already aware of that. When all the efforts of persuasion for when all the efforts of persuasion for recovery of a trade credit extended by a trade creditor fail, a situation may force the trade creditor to initiate actions under IBC. This slide narrates the process to be followed by such persons. Section 8 of IBC indicates that what is a detailed process for initiating insolvency. First condition is existence of operational debt. Debt should satisfy the canons of operational debt. There should be occurrence of default, and the amount of default should be beyond the threshold limit. When the IBC was formulated, this cutoff limit was ₹1 lakh, and in the COVID-19 pandemic, the threshold has been enhanced to ₹1 crore, and the same continues as on date. Next condition is delivering a demand notice in form 3 or 4 of application to adjudicating authorities. Here the key word is delivering, not sending. This means that whatever demand notice is sent, it should reach the corporate debtor successfully. There are two methods of demand notice prescribed in the Act. Two formats are prescribed, one enclosing the invoice and demanding payment, and the second one is descriptive form of demand notice without enclosing the invoice. Thereafter, the operational creditor is required to wait, afford a period of 10 days time to the debtor to respond. If there is no pre-existing dispute, or if payment is not received on the delivery of a notice, the debtor can initiate CARP. Initiating CARP involves filing of application in Form 5 before the adjudicating authority, and also making payment of a fee of rupees 2,000 by operational creditor as per the rules. What to call? To understand the existence of dispute, the Act defines all those things. We are not going to discuss much on that. Next point is, this is slide number 8. This slide indicates the documents that are required to be submitted by an operational creditor along with the application if he decides to initiate CARP. They include demand notice, affidavit to the effect that there is no notice is given by the corporate debtor about any pre-existing dispute, copy of the record of default from IU, and copy of the record from IU confirming that there is no payment received or unpaid operation rate by the CD if available. See, next point for consideration is what are the aspects or conditions that are going to be verified by the adjudicating authority, that is NCLT, while accepting the application so filed. Application will be admitted if application is complete in all respects, there is no payment of unpaid operational debt, demand notice is delivered, and 10 days period is over, and no notice of dispute is received from the operational debtor, and no disciplinary proceedings are pending against the IRP wherever name of the IRP is proposed. More importantly, before rejecting an application, an opportunity will be given to the operational creditor to rectify the defects within 7 days of notice. Once the application is admitted, these are the steps of calling a vertical, declaring the moratorium, making public announcement, invitation of claims, receiving the claims. This is the whole process of IRP. I am not going to discuss this in detail. See, now I'm going to tell you what is NeSL. Many of the customers will be inquiring whether it is a private company, what is this and all.
Mr. Venkat, before going, there was a question from Mr. Venkatakrishnan Natarajan. He was liking to know whether NeSL is an agency, credit agency, or it's into looking into the credit arrangement. It reviews it, whether it has a credit history of rate agencies, all those things. Whether how is it differing?
I'm going to clarify that, sir. When I talk about a brief about NeSL, this is introduction about NeSL. NES is incorporated in June 2016 as a Union government company, and NeSL is only an information utility under IBC and regulated by IBA. It is not a credit information company. The functions of credit information companies include collecting the data, give history about the credit repayment behavior of the customer. The objective of IU is totally different. Whatever data is submitted by a creditor to NeSL, the core functions of NeSL include present the financial information so received from the creditor to the debtor, obtain his verification and authentication electronically, and store the authenticated data with it. So whatever data is stored with NeSLIU is function is totally different from a credit information company. Credit information company is going to study the credit behavior. Here we are going to obtain the verification and authentication of the counterparty that it mostly it is data. So whatever is stored by us is verified and authenticated by the submitter, that is creditor, and also by the data, and then it will be storing it. These data stored with us in this process is accepted as a legal evidence in the event of default by the adjudicating authority, that is NCLTs, when corporate insolvency process begins. So that is a main distinction between credit information company and information utility. Functions are totally different. This is mainly meant for supporting the IBC insolvency resolution process as a legal evidence under IBC. So when you see the constitution of what you call NeSL, NeSL is the information utility and it is regulated by IBBA. It is registered with IBBA and regulated by IBBA. More importantly, when people ask, is it a private company? It is not so. 65% of its capital is held by public sector enterprises. It is owned by them. So it is not a private company. Then this is a slide which indicates about the data held by NESLIU on financial credit. These are all the numbers. What is more important in this slide is um, RBI at the end of every calendar quarter, they will be publishing the details of credit extended by the banking sector in the form of statistics to in the public. They call it basic statistical data. We call it BSR statistics. It is observed that NESL is holding about 90% of the credit extended by banks by value as per BSR statistics as of December 2021. So we captured the market to the extent of 90% under financial credit segment when we look the position as at what you call RBI statistics as of December 2021. So this is the data filed by operational creditors with NESLIU as on 31st May 2021. A total number of 794 operational creditors have filed data with IU. What we mean by data is loans without defaults. The total operational debts covered are 1,85,000. Number of operational debtors covered are 3,206. Amount of operational debt covered is 42,495 crores. When we consider the default reported loans segment, defaults are reported in about 958 operational credits. Amount of debt covered is 2,616 crores. Number of records of default issued are on completing the authentication are nearly 771. So next slide, this is very, very important. How exactly NESL is supporting the operational creditors? First point is before extending the trade credit to a client, the credit facility report that is being provided by NESL is useful in conducting the due diligence on the new client. When you want to lend an amount by way of trade credit, you wanted not to know the background and what is his indebtedness and full details about the 360 degrees view of his indebtedness on the debtor. My reports give you full details about the new client and you can take this is going to help you in conducting due diligence against a party before any operational creditor extends the trade credit. That is the first benefit in dealing with information utility by any trade creditor. Second point is when the trade credit is in progress during the pendency of the trade credit, NESLIU is going to help you with the alerts on defaults and a broadcast and public announcement. His dealings with this particular trade creditor may be satisfactory. There are no defaults. Promptly repayments may be coming, but with other creditors, he may be causing defaults. In such an event, you should have an intimation. Your transactions are okay, but the same debtor is defaulting in payment to the remaining creditor community. You are required to get the intimation by way of alerts in right time so that you will also be careful to decide in future whether I should extend trade credit to him or not. If I have decided to extend credit, to what extent I can give. This thing is going to immensely help. Not only that, when CIRP is initiated against the same trade data by some other creditor, public announcements are being made, and those public announcements we are going to broadcast to you when a trade creditor is dealing with NESL. If you are not dealing with us, we will never know that you extended trade credit to a particular debtor. When you are dealing with us, I'll be able to give you alerts on defaults as well as broadcast and public announcement to you in right time. Third category, after extending a trade credit in an unfortunate event of operational debtor committing a default in payment to you, you can always build pressure on him with a demand notice issued through IU, with a record of default issued through IU, and ultimately, if the situation really warrants initiation of corporate insolvency, the record of default that is going to be issued by IU is going to help you as evidence for a default, and this will help you as applicant to CIRP in getting the application quickly admitted by adjudicating authorities. Next is how exactly operational creditors can send demand notice and how we are going to support you. Is the next. We are going to discuss the details as to how NESLIU can support the operational creditor in sending demand notice and also with evidence of default and also in initiating CRP in the forthcoming slides. All of us are aware, even for sending a demand notice, there are many consultants, they charge amounts exorbitantly. See, the role of IU commences and is helpful to an operational creator once he starts submitting the details to operational create on operational create to IU. Unless you submit the data to us, I cannot recognize you as operational creator at all. So section 215.3 on procedure of submission of financial information states that your operational creator is required to submit the information to IU in such form and manner. The procedures of submission involves first operational creator is required to register with us as user on my platform, duly disclosing his identity, that is what is a PAN, and what are the contact details like what is the address, email ID, and mobile number. Thereafterwards, submission of information happens in Form C. It is online submission, on-screen data entry. You can submit in electronic mode. When operational create transactions are more in number, when he is having many operational creates, he can also submit through SFTP, through Secured File Transfer Protocol, either from front end or from back end by way of upload when there are more loan records on operational create to be submitted to IU. There are mandatory fields. There are validation checks. Once successful submission is complete, the submitter will get the confirmatory email from IU. The procedure is simple. We have got a help desk to guide and assist you. We will handhold you. Within a matter of 20 minutes to half an hour, all this process can be easily completed. Next point is, in the unfortunate event of default, one of the options is we should build pressure on the operational data to make repayment. What is first, normally you people issue a registered notice. He may respond, he may not respond. When you want to invoke the provisions of IBC, you are required to send a demand notice. See, for sending demand notice, normally if you engage a consultant, people charge very large amounts. Instead, if you are availing the IU services, procedure is simple, cost is less. How it is going to happen, I'm going to explain to you. While submitting the financial information on a corporate data, the operational creator can also upload a soft copy of the demand notice if he has already addressed it. Before coming to IU, if he has already addressed notice, soft copy can be uploaded. In cases where demand notice is not at addressed to the corporate data, NESL is going to offer you a service. That service is, it is going to generate and address the demand notice to the corporate data under the digital signature of the operational creator. This option needs to be exercised by the operational creator in the EU module while submitting the data. So far, I have not sent the demand notice. I want help from NESL in sending the demand notice. Based on the data submitted through data submission process, system will generate a demand notice addressed to the trade data, and under the signature, digital signature of the trade creator, notice will be pushed to electronically to the trade data. And the fee for the service is only 300 rupees. The demand notice would go from NESL to the corporate data by email, and its delivery is tracked and stored in its database. Information is available for the creator to view at any point of time. In such cases, there is no need to separately upload the demand notice addressed to the corporate data by the operational creator into NESL IU module. It saves effort, time, and costs on the part of operational creator. The operational creator can download and send the above demand notice to corporate data by registered post also as an additional service if he so desires. So addressing the demand notice process is made very simple. It is costing only 300 rupees, and all operational creators can avail our service in generating demand notice from our module while submitting the data on operational create to IU itself. On success, next point is how the process happens thereafter. On successful submission of the financial information of default by the operational creator, as per section 3.9, section 3.9 defines what are the core services of IU. NESL is going to refer the matter to the corporate data for his verification and authentication, default authentication from the counterparty to the debt with his digital signature on our IU platform. There is a standard operating procedure prescribed by IBBI in the IU regulation 21. And this is required to be followed for this purpose by you. Once the authentication process is completed, authentication status is categorized into three categories. Authenticated, that means he is admitted, or disputed with disputed remarks, or categorized as deemed to be authenticated with color codes. If he is not responding to the original email, followed by 3 reminders, giving 3 days each time, he's a total, if he's totally silent, in spite of successfully delivering all my communications, then it is categorized as deemed to be authenticated as per the provisions of IU Regulation 21. And for each category, color codes are also given for accepted, disputed, and deemed. Green, yellow, green, red, and yellow color codes are also given. Thereafterwards, record of default is issued, and this record of default is going to be accepted as a legal evidence in CIRP process as per provisions of IVC, thereby facilitating quick admission of the application for CIRP in a time-bound manner. This is the advantage. Then the natural question is what this record of default will contain. This record of default will contain what are the details of parties connected to the debt. Who is the creditor? What are all his identity particulars? Who is the debtor? What are all his identity particulars? Address, telephone number, email ID, who are the key personnel. Then what are the history of submissions made on this financial information? What is the information on debt and default? What are the details of authentication, invitation emails sent or communications sent? What is the status of delivery of emails and communications to debtor? Here important point is when we are sending the emails to the corporate debtor, my software is capable of tracking the events of delivery and date and time and opening of the emails also. All these events are recorded in our database and they are embedded in the record of record of default given, so that even adjudicating authority will also see whether the demand notice or the invitation for authentication has been successfully delivered to the debtor or not. If so, on what date, what time. All these events are recorded and reflected in the record of default. And finally, article authentication categorization made, that is also furnished there. Beyond this, Section 65 of the Indian Evidence Act clauses, it is accepted as legal evidence even under the Indian Evidence Act. Those clauses are embedded, and finally, it is digitally signed by the authorized signatory of the NeSL. This slide indicates what is the relevance of IU for establishing the default. Section 9395 provide that we should produce and all. We are not going to discuss these details in this thing. And these section 65B, section 31, section 115 of Indian Evidence Act give evidentiary value to the record of default, so that adjudicating authority, that is the NCLT, is going to accept this as the legal evidence in the corporate insolvency resolution process. Some people inquire, you are categorizing the authentication status in some cases as deemed to be authenticated. Is it valid? Is it acceptable? This is the recent court judgment dated 18th May 2022 by NCLAT, National Company Law Appellate Tribunal. They held that when the record of default is submitted by as an enclosure to an application, the adjudicating authority or appellate authority are not required to further examine the record maintained by the IU. So this is straight away accepted as an evidence. There need not be any doubt about the admissibility of forwarding as an evidence. Okay, now we are going to come to discuss another important point, that is applicability on limitation. This is an important slide. When banks or financial institutions extend financial credit, they have got a lot of machinery and manpower and systems in place to ensure that the limitation of liability is taken care under Limitation Act. And they do obtain acknowledgement of debt, acknowledgement security as a system of their working. But an operational creditor may not have such a system or machinery to focus on the angle of the limitation. Section 238A of IBC, this says the provisions of the Limitation Act do apply for appeals or applications or proceedings before NCLT, NCLAT, DRT, and so on. Prior to introduction of this clause, there were many divergent decisions on the aspect of applicability of Limitation Act to actions under IBC. Some tribunals held that Limitation Act does not apply to IBC, as the action is not for recovery, but for money, not for recovery of money claim, but to initiate insolvency process. Some tribunals held that IBC came into effect on December, so it applies only after 1st December. But now, with the insertion of this clause from 6th June 2018, it is a matter settled that Limitation Act is very much applicable to IBC. It is specifically provided that Limitation Act does apply to all proceedings under NCLT, NCLAT, and DRTs. For example, if recovery against an invoice is time barred, the application of CRP based on such invoice cannot be entertained. This is going to affect the operational creditors. What I mean to say is, if recovery against an invoice is time barred 3 years is over, the application for CRP based on such an invoice cannot be entertained. So this slide indicates the jurisprudence on applicability of Limitation Act. In this case, it is clearly settled by the Supreme Court. The Limitation Act is very much applicable to the applications filed under Section 7(9) of the ABC Code, right from the inception of the code. So the right to sue accrues when default occurs. If the default has occurred over 3 years prior to the date of filing of application by an operational creditor, application would be barred under Article 137 of the Limitation Act, and and you'll not be able to initiate any action. So every operational creditor is required to keep the limitation aspect in their mind always. Now let us see how NeSL is going to support OCs with evidence in filing their claims when a CRP is initiated by other creditors against an operational creditor. See, Regulation 12 of CRP regulation says creditor is required to submit their claim with proof on or before the last date mentioned in the public announcement. Insolvency professional is going to make a public announcement. He is inviting claims. He is giving a last date for submission of claims. Creditor who fails to submit the claim with proof before that date may submit the claim up to 90th day. So there is a second opportunity up to 90th day. Section 31 of IBC says once resolution plan is approved, it shall be binding on all the people, including all authorities. Suppose any operational creditor is missing to prefer the claim or submit the claim with proof to insolvency professional before this 90th day. Once resolution plan is approved, even if you make a noise thereafter, your claim is not going to be admitted. Whatever resolution plan is approved, it is settled. And for old liabilities, no action can be taken. Section 32A also strengthens this point. For all prior offences, including liabilities, once a resolution plan is approved and it is resulting in change in the management or control of the CD, you cannot claim. The summarized effect of all these provisions is that in case of delay in filing the claims by an operational creditor beyond the permitted period, it leads to their claims not being admitted and extinguished once a resolution plan is approved. See how much damage is happening. To strengthen this, there are jurisprudence, there are settlement, there are Supreme Court judgments. It is going to reiterate the same point. They said nothing doing thereafterwards claim cannot be entertained. This is Supreme Court judgment in this case. So now, when that is a position, what is the relevance of IU and how NESL IU can help you in the matter of claim submission? See, whenever in cases where a debtor has defaulted in making payment, NESL IU, after completing the default authentication process and categorization, is going to communicate the status of authentication of default to all the registered users who are the creators of the debtor. That means your transactions with your operational debtor may be running well, but when he defaults in making payment to another creditor, it could be financial creditor, it could be operational creditor. If there is a default to any of his creditors, such event will be communicated to you by way of an alert, provided you register with me and you submit the information with you. Otherwise, I cannot recognize you as an operational creditor at all. Similarly, when somebody initiates a corporate insolvency process against a corporate debtor who is your trade debtor, I am going to make public announcement. Look, so and so authority, so and so financial institution, or so and so operation debtor has initiated CRP against him. This is the last date for filing claims and all. Come on, get alert and try to file claims before the due date. So these two initiatives from us are going to help you to submit the claims in time. The next point is in such a cases, how it exactly it is going to help, that is alerts and broadcast. Next point is regulation 7 of the CRP regulation says operational creditor when he submits claim, he can prove his claim based on the records available with IU. I am going to give you what you call the authenticated data held by IU. What you have submitted, what is authenticated by the opposite party. That record of Form C is going to help you as a proof to be submitted along with your claim whenever CRP happens as a evidence of evidence of debt. Similarly, insolvency resolution professional also is mandated to verify the information with IU when he is going to validate the claims and decide to admit a claim or to reject a claim. Therefore, the services of information utility to operational creditors are going to facilitate submission of evidence of its claims to the insolvency professional or liquidator in case of liquidation, and it is going to immensely help you. Next point is what are the other benefits information utility can get it. The data or financial information submitted by an operational creditor to NeSL is stored in a safe and secured manner. Many operational creditors inquire with us, sir, trade credit, we do not want to divulge our information to our other competitors in the trade. So my information, how much I gave credit, how much he owes me, we do not want my competitors to know. They express concern whether information will be leaked to other competitors in the trade or industry. There is no threat of confidentiality or data loss for the information submitted by an operational creditor to IU. It is going to lead to cost savings. User registration by operational creditor on IU platform is free of cost. The information utility service is available to operational creditors at a nominal cost of 60 rupees for submission of operational credit. For each loan record, 60 rupees we charge. For generation of demand notice, we charge 300 rupees. NeSL IU is also going to offer you a credit facility report. It is debtor consent based. This is going to help all the operational creditors in conducting due diligence on a debtor before extending any trade credit. The fee is 100 rupees for each report is downloaded. If you want to extend a financial PQR company on that company with consent, you will be able to generate a credit facility report. It is going to give you a 360 degrees view of indebtedness of the debtor with details of what are the limits enjoyed, what are the outstanding liabilities, what are the overdues, what are the defaults occasioned, if any. Creditor wise, full details will be available to you. So it is going to give you a 360 degrees view on the new client so that you can take a call in the process of due diligence whether I can extend trade credit to this entity or I should avoid. NeSL is also going to offer you digital document execution platform. Any contract, it could be a operational contract, what you call, you may appoint people as a distributor or sole distribution agent or retail trader. Whatever contract you are going to enter into with your clients, all such contracts in digital form can be executed on our digital documents execution platform. We'll be discussing that in the next presentation to be presented by my colleague. Next point is people were expressing concern about the information submitted to us about the confidentiality, security, whether data will be lost. Tomorrow you may say that I cannot give you a record or default. It is not so. Storage of information by is done by NeSL by availing the data storage services with control S. It is a first tier data core center. It has a totally dedicated cloud services solution. No other company shares our infrastructure for storage. It is in India as per IBBA regulations. Service level commitments are to the extent of 99.995. It is ISO 27000 certified. Data center is at Hyderabad. Disaster recovery center is at Mumbai in a different seismic zone. Data is stored in a very, very safe and secure manner. About confidentiality and security of data, you are going to submit as you need not get worried at all. See, this is what we wanted to present it to you. Thanks for your patient listening. Thanks to BCIC and Dr. Om Prakash for affording us this opportunity. Any clarifications on this presentation are welcome. We'd be glad to clarify. This would be followed by a presentation from my colleagues.
Thank you, Venkat Rao. It was a very deep insight of the entire CIRP process itself. Actually, I felt as a refresher course. In a nutshell, you have detailedly explained the process of NCLT and also the NeSL, wherever, how it is going to be related and what is the nature of report and how the repository works. The only thing which I would like to question you is what can be the process of redressal from for NeSL, if it is found defaulting or, if there is any lapse from NeSL. What is the mechanism? Is it the regular civil suit procedure or high court, or you have a inbuilt process where it should be addressed by, like how SEBI has been doing?
So actually, our process is totally system driven, without any manual intervention. What is the process we are required to follow has been spelled out clearly by IBBI and IU Regulation 21 in obtaining verification and authentication by the data. So that process is religiously followed without any omissions. Number one. Number two, about the correctness of the process followed and all, before giving license to us, IBBA has deputed a technical team led by Professor Sharda to our office. They conducted what you call audit of the process and also the functionality of software as per the standard operating procedure prescribed by IBBA. Only when they are convinced, then only they give us the license. Beyond this, in case any the client dealing with is having any aberration and doubts to clarify, we have got two initiatives. We have got a help desk to seek any clarifications. Beyond this, we have also a grievance redressal mechanism. We have published the email IDs and toll-free numbers in our website. They can what you call it, contact us either on our help desk and toll-free number on email ID. If they got any grievance, they can lodge a grievance also. We will be glad to re-verify the point raised by the client and will be resolving the issue to their satisfaction. So absolutely, there is no deviation in any manner from the standard operating procedure prescribed by the IBBA. And then all the process carried out by us is system driven with complete audit trials. So there is no threat of any, no need for having any doubt and no threat of any uh, other method.
There's a question from one Mr. Prashant Sebastian. So he is a corporate lawyer, and his question is, uh, currently understand that based on IU data, either operational creditor or the financial creditor has to use the data and file a claim under IBC. In the absence of above, can RP rely on the same and Suemoto ask the IU to share data concerning any corporate data as part of the insolvency process, even though the OC and the FC may not have filed claim? That way,
Yes.
there is a less onus on OC and FC, and at the same time, RP can rely on this data.
Yeah. See, a good
So
question.
that's an RP without the OC and FC's claim. Can he initiate and rely on this data? Is what is this question is?
Yeah. It's a very good question indeed. The provisions are like this. An insolvency professional appointed as insolvency professional or insolvency interim resolution professional, upon his registering with us and upon his indicating and submitting the proceedings of NCLT that he is appointed as an insolvency professional like case, we do link that particular data to that particular IP. So he is provided with the access to see all the data or defaults reported by the creditors on that data. It is available to him during insolvency resolution process. So next question, he is going to use this data in two ways. First one is when he receives claims, he can compare the claims with reference to authenticated data with IU, and in the process of validation of claims, it is useful. Second one, he will be able to know who are all the creditors to this data, and in constituting the committee of creditors in CARP or in constituting the committee of stakeholders committee in liquidation, my data is going to be helpful. So it is going to give him an indication that who are all the creditors to the debtor undergoing insolvency or liquidation. He will have an idea. So he is provided the access as per the IBC. Data is available for viewing. He can rely on this data and validate the claims and also forms a committee of creditors based on this.
I think we have lost him. Can we have the next presenter from NeSL team?
Yes, sir, I am available.
Sir, Om
Yeah,
Prakash,
please.
thank you. I am what do you call it? Muting my mic. Thank you.
Good evening, sir. I will share my presentation. Yes, sir. I am Vaidya here from NeSL. I am making a presentation on digital document execution, e-Udbhavam, and electronic bank guarantee. These are the three services what NeSL is providing or going to provide. See, what is the digital document execution? It is a new way of contracting experience. It is faster, secure, efficient, cheaper, and it is creating a legal evidentiary value. It is NeSL is a repository of legal evidence. So this is one of the legal evidentiary value in information utility. Uh, Digital document execution is NeSL is mandated to serve as a repository of legal evidence of financial credit contracts. Somebody asked, what is the difference between other credit information centers and NeSL? Sir has responded very well. Basically, the bankers, whenever they are lending to the customer, that debt information is passed on to the bank to NeSL. Whenever information is received by us, we are going back to the customer, whoever on whom the information is submitted. To the debtor, we'll send an SMS, we'll send an email, tell that this particular banker has submitted information on the debt taken by you. Then at that particular moment, the debtor will come on my platform, register himself and acknowledge the debt. This is the difference between NeSL and other credit agencies. Credit agencies only accept the information received from the bankers. But here there is a difference. Here I am asking your customer, that is a banker's customer or a financial creditor's customer, that is a debtor, to come on my platform and accept it, acknowledge it. This is an authenticated information available in my system. That is the difference between NeSL and other credit agencies. And digital document execution is also going to prove the debt created by debtor. So RBI has directed many of the state governments to ensure that digital stamp paper is linked, given to the NeSL, and simultaneously it has asked the bankers and other creditors to use digital document execution platform provided by NeSL, a secured way of doing a contract. So the workflow is very simple. Is very good actually. What it does is it enhances the ease and security, convenience to the public. It operates on 24/7 and remote basis. Person need not be here. You can have a contract. A person may be sitting in Delhi. A person may be sitting in Bangalore. You can have a contract, execute a contract by obtaining a stamp paper on my platform. You can obtain a stamp paper, execute your own document. That is digital document execution. And it facilitates conclusion of the document through a e-signing and digital e-stamping. E-signing, there are different ways. I will be detailing you in the further slides. It facilitates contract completion instantaneously. It obviates the need for physical presence of the customer in the present pandemic time. People need not be in front of each other to have a contract signed, and their contract may be consisting of so many pages which require so much time to both of you them to come and sit at one place and execute the document. So that way this digital document execution helps. It reduces the processing time. It reduces the storage cost. How it is done? We have a it is a dematerialization of your document. It is a dematerialization of the document in a stamp paper. Banks use their own templates. We have done more than 5 lakhs transactions of digital document execution in our platform. Many of the banks, about 23 banks are using our platform to execute the routine documents. Even some of the customer bankers are using the MSME accounts, the corporate accounts to be executed on my platform. They can use a DSC. Then online stamp duty of each government. See, each stamp duty is a state government subject. So each state has got its own way of stamping and obtaining the stamp duty. There may be different ways of different types of articles are there. Accordingly, each state is having its own stamp duty. Example, Tamil Nadu is having a 20 rupees for an agreement, and whereas in Karnataka it may be 50 rupees or 100 rupees. Maharashtra it may be 500 rupees. Delhi it may be 100 rupees. Like that, each state has got its own stamp duty, and I will be I am linking to each of these state governments and obtaining the stamp duty what you require. If the bank is in Delhi, then I'll obtain a Delhi stamp paper. If it is in Tamil Nadu, I'll obtain a Tamil Nadu stamp paper. It is like the contracting parties will decide from where the stamp duty is to be obtained. And this also supports, which we are thinking of in the future, we are going to have a loan exchange platform. In that case, the document can be just transferred from this place to another place. So it will be really a fantastic way of doing the business. It is offered as a service to lending institutions, and demat contract generation. Your own, that is the bankers are sending their own contract, their own format. There is no specific format of NeSL. It is a format of each bank which will be sent to us. Then I will obtain the digital stamp paper of the concerned state. I'll obtain the digital signature of the customer, maybe Aadhaar based, OTP based, biometric based, or DSC. Then documents are stored in a simple library of a customer as well as us. And DD is in place of the 23 states in India: Andhra Pradesh, Assam, Bihar, Chhattisgarh, Gujarat, Himachal Pradesh, Jharkhand, Karnataka. Any of these places, your customer can be there. We can execute the document. Kerala, Madhya Pradesh, Maharashtra, Meghalaya, Odisha, Rajasthan, Tamil Nadu, Tripura, UP, West Bengal, Punjab, Andaman, Nicobar, Delhi, Jammu and Kashmir and Pondicherry. We are in the process of having more number of states. I would like to cover by the end of this year. All the states may come into my platform. Many bankers are using this platform. This is about digital document execution. The same thing. This is for the banking contracts. Now we are making use of the same platform and help the operational creditors. What we are talking is so many debtors and so many industries are there. They are having their own businesses, and they may have a borrowing arrangement with the banker, or they may not have a borrowing arrangement with the banker. But each one requires a contract at one time or the other time, maybe with his employer, with his contractor, with his supplier, or anything else. There is a contract. Any agreement you require a contract. Then when the contract comes, it may be digitalized or non-digitalized. It may be registrable, non-registrable. Like that, there may be variation, but I will be having a digitalized document only for non-registrable documents on my platform. It enables the execution of a contract, a document between two parties using a pre-filled document uploaded by the creditor and banker, online payment of stamp duty, Aadhaar-based signature. Contract can be saved in demat format. It can be used as an evidence in case account goes bad. And in case of bankers, a large number of contacts are there, then application protocol interface can be used. This one is being extended to operational creditors. How? This is a web-based platform to execute the documents between two parties electronically. It enables ease of doing business wherever he or she is sitting. Then it enables the citizens and businesses to execute non-registrable agreements and documents on digital platform. Entire journey is electronically driven. Document execution will be completed electronically. It is a paperless mode. Presence of people is not at all required. But if you want, you can have a biometric signature. You can have it your own place. And operational creditors, users of e-Udham can upload their own agreement. Maybe it may be temporalized document to be executed online. Payment of stamp duty is online payment. We will be using the digital gateway and digital signature. How is the process? See, many of the debtors, many of the industries, they may be banker. I don't say that everybody is a borrower. Some people may have family business which no loan is taken and they are continuing. There may be some people who are taking a smaller loan or a bigger loan, but money is more important. You may also lend it to somebody else. So you are either debtor or a creditor. So in one way or the other way, there is a loan, there is a contract. So we are there in between. So we can be used. When the banker sends an information to you saying that you have borrowed from SBI, you have borrowed from Canara Bank, this is the amount they have reported against you. At that time, as and when the banker submits the information, I am intimating to the industries. the concerned company. The company is coming on my platform and registering himself or herself or the company itself. Then he will be acknowledging the debt. So this gives a that I owe the money and I am doing the business. That is what you are going to say. It tells about your character. It is a good thing if you come and acknowledge so that people have a confidence on you. So in this case, you are already a user of information utility. You are already registered in our information utility. Then what happens when you want to take loan? When you want to take loan, conduct an agreement, complete an agreement. At that time, you can go to IU, you can go to e-Udbhavam. Then you can invite the other customers. You can invite the other customers. You can invite the individual, you can invite the corporate, you can invite other business entities. It may be for loan or non-loan documents. Both the things are coming here. Upload the documents. Once you invite the customer, your other party, you can upload the document and the other party can come on my platform, buy a stamp duty of what state he wants to have. We have all the states will be enabled shortly. Now, as of now, Karnataka is enabled. Agreements can be executed online. It will be put on a DMAT format. See, your agreement form may be about 3 pages. When you submit the document, I will be showing the same to your other contracting party, party number 2. He will go through the document after identify himself. He'll go through the document and say, yes, I agree to execute this document. Then at that particular moment, I'll be buying a stamp paper. What stamp paper? It is a 200, 500 or 1000 rupees, whatever you have told. That particular amount of stamp paper will be purchased and affixed to the as a first page to your document. And your 3-page document will be subsequent. And this 4-page document will be made as a single document and it cannot be detached and put back to the contracting parties. Contracting party 1, whoever has uploaded, then he will go through the document, he will see the stamp paper, he will see the agreement format, whatever you have sent it in a PDF, uploaded in a PDF format. This document he will digitally sign. What are the ways of doing signature? You can use Aadhaar-based signature. You can use a Aadhaar-based TOTP. That is the TOTP is the latest one, wherein Aadhaar is downloaded in your app. Then you can generate an OTP. You can put that OTP so that your digital signature will be put on the contract. Or you can use a OTP for mode where OTP will be put in the system. Then your signature will be affixed on that. Then it will go back to the second person, third person. If you have a similar for so many number of people, they all will be going through the document in the same way and come back to the original person. So this way, all of you can execute a document in one way. So the agreement can be between individual to individual, corporate to corporate, other business entities to other business entities, or anyway, corporate to individual, corporate to business, or corporate to individual. Anyway, this can be done. This can be done for a non-loan documents also. That is because operational creditors, you may have a supply contract, you may have a guarantee agreement to somebody else. All those things which are non-registrable can be done on my platform. You can have there is a dashboard where it will show you what are the agreements which are available for you to execute the document. You enter the agreement details. It will give the details, then upload agreement copy. Individual associated in an agreement will be identified, process by an OKYC. Continue the agreement submission from pending agreements. You can view all the executed agreements. This platform is available so that you can use the MIS here. History of all the agreements, whatever this particular person who you have done with various people will be available here. You can download the executed agreement. You can view the agreement online. You can verify the agreement details. And pending agreements, what are all things which others have submitted to you, which you have to execute. This MIS is also available to you on your IU platform. You can select the agreement reference, continue from where you left. You can do halfway. Now only you don't have a time. When you go back home at that time, you would like to see at leisure, you can see at your leisure time, then execute the document, pay stamp duty online by a payment gateway, submit the agreement. All these are simple procedures, and web-based application is there. So as I told you, you can execute the new agreement, view executed agreement, view pending agreements. This is a really state-of-the-art facility available to all operational creditors who can register themselves on my platform. What are the documents that can be executed? Lease agreement. Example, there is a lease agreement between you and the owner of the building. This can be done. Undertaking with the government agencies, use of utilities like electricity, etc. You require a contract to be signed before taking a this electricity supply to you. That can be done. Agreement with suppliers, vendors, lease of premises, agricultural tenants, sharecroppers. Agreement with insurance companies, mutual fund businesses. If you are a mutual fund distributor, then you have so many people working under you. You can have an agreement, employee-employer agreement you can have. Lease agreements by broking firms like OYO, Homes, No Broker come. These people also come on my platform and execute the document. He can help the owner of the house and borrow who is going to be a tenant. So that can be executed on my platform. You name it, that can be executed on my platform. Only thing is it should be non-registrable document which can be done, because the registrable document has got its own checks and balances which government doesn't want to give it on the e-platform. So e-Udbam platform, various signature formats. There is no need for multiple signature on multiple pages. No more hassles of signature mismatch. People can come and say later on, no, this signature is not mine. But that cannot happen here because it is a OTP based, it is a biometric based, or it is a DSC based. Nobody can deny having executed the document. Is a mobile friendly platform, web based platform, Aadhaar based OTP sign, I told you, biometric based sign, dongle based signature is there. Evidence is maintained. If you ask me, you give me an evidence of executing the document, then I will tell you when your other party has executed the document, when he came on my platform, when he entered his OTP, when he agreed to buy a stamp paper, all these electronic footprints are available with me. I can give you in case your agreement has to be executed in the court of law. Then it is a paperless comprehensive process that integrates with lenders. Maybe it is a lender or others. If it is a general public also, if you are having a large number of contracts to be agreed, then APIs can be used. Templatization, your own agreement format can be uploaded. It can be a unique or it can be a multiple documents. It can be your own. And digital e-stamping, as I told you, it is obtained from the shield or grass state. Some state governments have given shield, that is a stockholding corporation of India Limited, to issue a stamp certificate. You can use that, or some states are directly selling the stamp papers. At that time, I will go to that particular government and get the stamp paper for you. It is digital contract. It will be merging the text document along with the stamp duty certificate. The uniqueness of this is I'll be combining these two documents and it cannot be separated after your signature. If you separate, then the agreement will become invalid. You cannot use that particular contract for any other purpose. So anybody tries to modify it later, anybody tries to change the term, change the amount, or anything on the document cannot be done. This is one of the unique secured feature of the e-Udbam platform. And document storage is available in our storage any number of years. You can see the contract. If you are executed for 3 years, it will be available for 3 years. It is available for 5 years, whatever you have told the term approximately when it ends. And there is a facility you can cancel the document which you have executed on this platform. Example, you have executed a contract for maybe you have not given the timeline for a particular contract. Then you can say this particular contract executed by me on this particular day is cancelled. Both of you executed, then it will be cancellation of the document done on my platform. Then it saves you cost. The cost of executing this document is maybe just equivalent or less than if your person goes and buys a stamp paper from a stamp vendor. he will be charging you your auto charges of 100, 200 rupees. It is less than that. So the cost of executing the document on my platform, sitting here at your place, purchasing the stamp paper is just, you can say, a nil. Cost is nil. You will not be paying a that stamp vendor. If he, when he sells the stamp paper, he will be charging you some commission. That also is not here. And it is safety, security, reduction in the fraud cases, secure online transactions. Aadhaar linked signing is possible, and there only, it is only when your mobile OTP you can put in that, then only transaction happen, or only when you put your thumb impression, that is biometric, then only the Aadhaar signature will come. So it is so secure, nobody else can use telephonically also. So two-factor authentication is available. You can even have, see, the registration process itself is so difficult that your matching, your face recognition is required in when you are registering on my platform. So the other person, when you are inviting, that person also has to identify himself. That face recognition has to happen on my platform with the Aadhaar number, so that beyond a particular percentage only it will accept. So nobody else can use your Aadhaar and your mobile and come execute the document. If may be possible, if only thing is I am capturing the photo of the person who is coming there. It is a very speedy processing in a very, I am seeing in the bankers, we are allowing so many bankers. I told you about 23 bankers on my platform. Once they submit the document on my platform, within 3 minutes, I am obtaining the stamp paper, allowing the customer to see the entire document, and taking his digital signature from CDoc or your DSE. It is just 3 minutes. I don't think anybody coming and sitting in front of you within 3 minutes we can complete any execution of any document. It is not possible, but it is now possible because of this e-Udbhavam and DDE platform. It is a very uniform process. Is very, by a click you can get it. What is not covered on this platform? What we cannot execute? Any class of document stipulated by central government, if they say this cannot be done, we will not be able to do. Sale of immovable property cannot be done. Interest, conveyance of the properties to somebody else, because these all requires a registration. Power of attorney. Power of attorney you cannot give here, because this is a place where he will be authorizing somebody, then somebody like a Tahsildar or a notary has to be present when he is giving this power of attorney. This needs to be registered. So this cannot be done on my platform. A will or testament cannot be done under this platform. A negotiable bill of exchange cannot be executed on my platform, and trust deed, etc. under Indian Trust Act cannot be done digitally. These are barred by IT Act. So I will not be able to permit anybody else to cross the line. Then this is about electronic document execution, which operational creditors can use for between themselves and their customers. Now we have come up with a new platform wherein we have a digital document execution platform. We have a separate private contracts which can be executed on my platform. Now this third one is electronic bank guarantee. Now what is happening in the bank guarantee? There are the possibility of misuse. Some of the contractors, some of the people are giving a fraudulent stamp paper, or they may be using the same stamp paper for something else. They are showing that this is a bank guarantee issued by the bank. Maybe that is not possible, that may not have been issued by the bank. So to avoid all these things now, and this is a physical, you have to go to the bank, you have to ask the banker to give a bank guarantee, then he will process it, then he will issue a bank guarantee, then he will be sending directly to the beneficiary of the guarantee, or he will be handing over back to the applicant. Then the applicant will go and give it to the beneficiary. Maybe he is in Chennai, Delhi. This physical moment time, it will be maybe 3 days, maybe 3 hours, or 3 weeks. We do not know manually how much time it takes. A particular document will take time to reach the other end. Till such time, the contract period or the tender period may get over. So you may lose the particular contract. You may lose a particular time. Time is the essence. So in such a situation, the significant time delay can be sorted out. and there is no central depository of e-bank guarantee. Bank guarantee is issued by the bank, only he knows. Nobody else knows. Cost incurred between the bank, then advising bankers commission, then signature verification commission at the other end, beneficiary end. These are an impediments which are adding to the cost of any agreement or a contract or any process, and difficult to prevent stamp duty revenue leakage to the government. So what we are doing in this process, the applicant will come to the bank will go through sanction and its own format of bank guarantee, whatever it is having, using it for regular bank guarantee issue, that standard format will be used. And it may be different for NHI, different by state road transport corporation. Whatever your format is there, that will be issued along with the bank guarantee given by the bank. It will be issued digitally, and beneficiary will be on my other platform. Means he will be also having an account with me, means he is also registered with NeSL. As soon as the banker issues the bank guarantee with a stamp paper, like what I told in e-Udbhavam and DDE, we are obtaining the stamp duty of the particular state. And after obtaining, we are attaching that bank guarantee. This will become a single bank document. This will be passed on to the beneficiary. It will be available in the beneficiaries I use platform, like what I told in our e-Udbhavam. See, view executed agreement. In this view executed bank guarantee agreement, he will be able to see what are all the bank guarantees executed by, issued by the concerned bank in favor of this particular contractor. Example, if X is the person who has requested a bank guarantee in favor of NHI, bank SBI or Canara Bank is issuing, then NHI would like to see whether he has received this bank guarantee. NHI will go to this particular platform. He will see whether any guarantee is issued. Immediately it is available in his platform. As soon as the banker signs it, it is available in his inbox. So he can see how many bank guarantees are there in his favor, how many people have come, how many people have applied for this particular tender. Use the PAN number of the person, it is available with him. So that way I am reducing the timeline, weeks or months or whatever is the timeline which is taken for traveling from one place to other place. This time is saved. This is available with the beneficiary. Beneficiary need not cross check again with the another banker. What is happening in the present day? SBI is issued a bank guarantee, then he will come back to some of the SBI branches and ask whether this is the sign of this bank guarantee, whether this bank guarantee issued by this bank. And you may again ask another bank to confirm it. So these are the processes which will take a week to 10 days. And it costs, this can be avoided because every NHI or anybody else, he can see his own inbox and see this is issued. And this is only available to the beneficiaries, what is this, registered users. Only they can see, not all can see. So it is a privacy between you and the banker and the beneficiary. Beneficiary can see only his beneficiaries, not somebody else's. And who are all have got the issue guarantees, he can see. So this way, this is a new revolution which is coming in the banking industry. This is what NeSL is looking at. It is completely digital and itself is a digital with a digital signature. It eliminates pitfalls of paper-based processes. There is a flexibility in using any BC documentation template as practiced presently. There is no need to migrate to standardized template across the country. Not only students, even we are looking for, this is over a period of time, we are looking for giving a chances for this amendment also can be run through this. Invocation of the bank guarantee can be done through, or a closure of the bank guarantee. In the present days, when you want to close a particular bank guarantee because you want to take one more guarantee, at that time you have to go and find out this particular beneficiary where you have gone. This bank document may not be bank guarantee may not be available immediately to you. This may be in different file, somebody else's file. So all these hassles of manual things can be avoided if you use this electronic bank guarantee, because there itself the beneficiary can say this can be closed. It will come back to the banker. Banker can close and waive off that particular liability on the customer. This quick issuance, ease of doing business is one of the important thing in this electronic bank guarantee. It is downloadable from NeSL by beneficiary. Banks are free to follow regulatory requirement of SFMS. That can continue for some time because this is more secure. This is coming into your own inbox. NeSL is a central EBC repository. As it is, we are a legal repository of legal evidence. This is another legal evidence where we can have it. Issuing bank can also store EBC issue. Ease of stamp duty enforcement. These are all about electronic bank guarantee, e-Udbhavam. I think I have covered. Any questions are there? Please.
Thank you, Mr. Vaidya, for this wonderful presentation.
Thank you, sir.
Now, with this DDE coming into force, the witnesses are not required. Normally, when
Not
somebody signs,
Yes, not required because for the simple reason, this authentication, there is a biometric authentication, OTP authentication, and he only does it. Nobody else is required there.
because now digital signature has been carried by various people, we don't know who has
Yes, sir.
really executed that.
Name will come there, down there. Whose digital signature is there? It will come. It cannot
No,
be
sir.
done again. There
What
are
I'm
OTP
saying
based.
is, if the boss is the person who is authorized, and
Yes,
the subordinate signs it off, tomorrow the boss comes and says, "Who asked you to sign?"
So it is a
Sir,
security
it is
like
like
giving your ATM card to somebody.
with a pin.
No, I'm just
Also,
giving
sir,
you a
it is like
scenario.
correct, sir. Sir, it is like as Vaidya said, if you give the ATM as well as the PIN to somebody, if he uses, you will be responsible. Similarly, it's like keeping a signed, blank check on the table. Somebody takes it and uses it, sir.
Correct,
It is
correct.
possible. Yes, sir.
So now
And some
this
question.
bank guarantee, which all are the banks who have been doing this, sir?
At present, we have about 6 banks which are testing this system.
Tested, yeah.
We'll be rolling out shortly. Beneficiaries we are enrolling. We can start it shortly.
The proof
So it
of
will
concept
become
has been
mandatory
done.
for the
Yeah.
banks. I think
Mandatory is not this thing. It will be, sir, because they will see the benefits and come on their own. It may not have to be made mandatory, sir.
so now we saw a lot of chat boxes queries have also been replied. I think nothing is pending there. Thanks, Shankar. Shankar, I think you were behind the screen and replying most of the queries. Thank you very much. And I really thank all the members who are present here and the participants, delegates who have taken time out and gain at least a bit of information what is all about NeSL. NeSL is a very complex subject and it is revolved 2-3 years and it is finding a position now. It is a new, actually I can say NeSL is the pioneer in IU and it is not tested actually. Whenever the problems are come, it is reactive. Basically, we have to react on that. We all are working together as a team. And thank you very much, Mr. Devajit Ray Chaudhary. It was a wonderful keynote you had given, giving the overview. And Venkatrao, you really ran through the entire gambit of the SAP process and how NeSL is very important in confirming the credit balance and borrower and how the NCLT really vouch on this document. I have seen if the document is not supported by NeSL papers, it gets rejected. So all the lawyers at least know for NCLT if they have to file a complaint, NeSL एक बॉडी है उसको जाके अप्रोच करने का है something like that they know they really do not know what is it. Of course the tip of the iceberg they know there's something called NeSL. We have to go and apply.
Sir, we have got a request to make, sir. All the what you call trade creditor participants in this seminar should commence availing cover IU services as OC. This is our request.
So operational creditors can voluntarily file it.
Yes.
No, it's a request. I mean, see, if you want to help yourself, do it. It is only for helping yourself.
Definitely, yeah. Thank you very much, Mr. Vaidya and Venkat, both of you, and thank you, the secretarial team of BCIC, especially Rupa, and more importantly, Mr. Shankar, who initiated the whole process. And I thank everybody. Possible, we can, again bounce in once the bank guarantee is getting a shape and is tested. So we'll again pitch in. Every year we are having one or two webinars on NeSL. So this year also we had it. So thank you very much for being with us, and thank you NeSL team. Kudos, wonderful presentation, and we enjoyed it thoroughly. Thanks,
Thank you,
team.
Dr. Om Prakash. Thank you so much.
Thank
It
you.
was a
Yeah.
pleasure meeting you. I've been hearing about you for such a long time. A pleasure
Yeah.
meeting you.
I will drop in.
Yeah, and
I will drop in.
It'll be a pleasure
And
to
our-
catch up with
and,
you in office.
Yeah, and also for organizing in such a short notice, and thanks to Rupa. Thank you.
Sir,
Thanks.
thank you very much, sir. Please
Yeah.
do stay with us, sir. We would like to just play a small
Yeah,
thank
yeah.
you video.
Sure.
Okay. Very
Thank you.
nice.
Thank you.
Thank you very
Thank
much,
you,
sir.
sir.
We
Thank
look
you very
forward
much.
to have
Yeah,
many more
thank you.
sessions.
Thank you.
Thank you.
Thank you.
Paste it here.